Welcome back to OpenLine. We were talking with elder law attorney Tim Takis, and we kind of set the table in the first segment. Of course, encourage you to call in if you want to call in, but I want to move to wills.
Yeah.
Because that always is interesting to people. And sometimes people get in fights over wills.
Absolutely, yeah. And sometimes it's just easy. You write on a piece of paper and you say, all to ma.
And that's legal.
Yeah. Now, we not necessarily recommend it, but, you've heard me, those of you who watch the show a lot know that we've talked about that you can actually write out your own will, and to my knowledge, and I don't know if it's but it sounds like a good story, is that some man died, and they found in his papers all to ma written on an envelope or a piece of paper, and somebody went to the court and said, "Here's the will." And it says, well, that's in the late Joe's handwriting, and we all know who Ma is, so they admitted it as a will.
Right.
Now, as I said, that's not something that we recommend, and
you probably leave yourself open to all kinds of problems if there is that chance.
Yeah, and we all know too is that if you pass away, or most of us do, is if you pass away and you don't have a will, the state has a plan for you.
Right.
That people have been dying for centuries and haven't had wills, and somehow property gets from one generation to the next, and it's because the law says if you die and you have children and no spouse, everything goes to your children.
Equally. Right? So you have 3 children, it goes 33.
And no spouse, right? If you die and you have a spouse and no children, then everything goes to your spouse, whether you want that to happen or not.
Right.
Some people do, some people don't. If
you're separated, but not divorced, it goes to the spouse.
It still goes to the spouse.
Right, right.
If you die and you have a spouse and children, and you own property, money or property separately from your spouse, and you have no will, then your spouse gets a share depending upon how long you've been married, and then your children get the rest.
Really?
So it's literally divided up.
So that's not automatic.
It's not automatic.
In fact, it is automatic that some goes to your children.
Some goes to your children, right.
All right, I didn't know that.
Yeah.
That's interesting.
If you have no spouse or children, then we say it goes up. It goes to your parents. If you have no parents, then it goes out, which means it goes to your siblings. If you don't have any of that, then it winds up going to the state.
Okay.
If you can't find, if you have no relatives that they can find, and then it's just basically held as as a part of the state holds it until, I don't know how long, a period of time, until someone shows up and claims it.
So you see this all the time.
Kind of like the Prince thing, people showing up and claiming.
I know, Prince has no will.
Yeah.
So the biggest mistake people make when it comes to wills, what would you say?
I think the biggest mistake that people make is they do not think enough about the impact of the inheritance on the person that's receiving it. Like, for instance, I alluded to just before the break, we talked about, especially, you're 80 years old and you have a special needs child. Then you're going to go, that's been in your part of your life for 60 years. Is how you're going to take care of that child, and then who's going to take care of that child when you're gone. So that's right up in front and center. But for most people, or I would say many people who have, who married couples, they don't think about the impact of their estate plan and the inheritance on their spouse. Mm-hmm. I mean, in some instances, like the 2 cases that we had today, and particularly the one individual, the married couple that walked in, they'd been married for 25 years but they had separate estates and separate children. I sort of explained to them is that, well, if you leave everything to your spouse and she's in a nursing home, that may not be a good idea. And the husband goes, oh, I never really thought about that.
Right.
And then the wife goes, well, your husband has a memory impairment now, and he has a history of Alzheimer's disease in his family. Do you want to leave half of the estate to him outright? Well, I never really thought about that. Because I think the idea is it's so ingrained in us, that we leave our estate to our spouse, regardless of what circumstances they're in, that sometimes, you have to stop and think about it is that maybe that's not such a good idea. What other options do I have?
And do you see some pretty just brutal battles when it comes to this? I mean, when people challenge a will, And could some of that have been avoided, or was that just going to happen anyway? I mean, anybody can write a will, and then any will can be challenged.
Yeah, and one of the things and it's funny that you mentioned that, because today one of those that came in and talk about their estate plan, they said, well, I've got, my son, I've got four children, and I don't want to leave anything to one of my sons, and so the will that I did, the lawyer told me I had to leave him something.
Right.
So I left him $1,000, and I kind of winced, and I said, well, there's no law that says you have to leave your children, anything. You can't disinherit your spouse without their consent.
You cannot disinherit your spouse without
their consent.
Or
right.
his consent.
Yeah.
I didn't know that.
But
okay.
The lawyer told our client, he said, well, I said, well, why did you leave your son $1,000? Clearly you got much more than that, and you're trying to disinherit him. And the lawyer said, well, I had to give him something, otherwise he could come in and claim that I forgot him. And it's like, well, why not just put in there that I leave my estate to these 3 children, and I leave nothing to this 4th child. Clearly you didn't forget him.
Right.
So he couldn't make that argument, and it's like, and the result is that what you're doing is that you're giving a person what we call standing. Okay, so that child can come in and say, well, Daddy left me $1 in his will, and I want my $1. Oh, by the way, I want an accounting of the estate. I don't waive bond or inventory, so I'm going to require that those be filed. And when you send me that $1 check, good luck in seeing whether I'm ever going to cash it. So in other words, you basically can, when the alternative would have been, look, I'm just going to leave. I'm going to acknowledge that my son or daughter is there, and I leave them nothing.
Now, I've heard that you should. I've heard people leave $1.
Yeah.
And I haven't heard 1,000, but I mean, I guess if you have a lot of money. So you leave $1 just to acknowledge them.
Right.
But you're saying that opens up all kinds of doors.
Yeah, because what you do is, like I said, is that they become a beneficiary of your estate, and the law does not look at a distinction between $1 or 1/2 of the total estate. They just say if you leave somebody a bequest, they are a beneficiary of your estate, and they have all the rights and privileges of a beneficiary. Period. That's it.
Wow. Okay, let's. I have more to ask about. Let's go to Sandy.
Okay.
Hello, Sandy.
Yes.
Hi. Go right ahead.
Yes, I have a question. My mom and dad passed away both within the last 2 years. My brother and I were both beneficiaries of the estate, and we were supposed to sell their home and split it equally. And it's been under contract to sell, and he moved into the home shortly before they passed away. And we signed a contract. He signed the contract to sell, and now we close in 2 weeks, and he says that he's not leaving.
Oh, boy.
And I just want to know what, I mean, he's under contract to move, but the realtor says she doesn't know what to do, and I don't know what to do.
That case, there was something in Nashville in the paper about that about 3 or 4 months ago, and I don't know if you recall it, where they sold the house and the lady decided not to move, or whatever it was. And, basically, he's going to have to get out, and that's going to be basically a detainer action. It's going to be, it's just like somebody that's holding over and not paying rent.
Right. So the ownership of the house would pass to the other.
Right.
Even if he owns half.
Right. And she owns the other half. And she has, I was just thinking is that Sandy has a right of occupancy of that property, just like her brother does.
Right.
Merely because he decided to move in there. But any co-owners have a right to live there, so she could move in, but she's not going to do that. But clearly he's going to be in breach. And the concern that I have for Sandy is that it may cost her brother something, but it should not cost her.
Right.
Unfortunately, she may wind up in a lawsuit with her brother where she claims damages because, the buyers are going to go, well, if it's costing us money, to get this person out, then it comes out of may come out of Sandy's share, and we don't want that to happen.
Now, Sandy, does that answer your question?
It does. Thank you so much.
Yeah.
Thank you.
Yeah,
Okay.
I mean, she has a legal remedy. Unfortunately, you can't just go in there and lock the doors and put him out. That's not the...
Yeah. Another example of how these things can become very tricky.
Very tricky, yeah.
These wills and that kind of thing.
Yeah.
All right, so we're talking wills, we're talking paying for nursing home, whatever you want to talk about. There's the number 615-737-PLUS, 615-737-7587. We'll take a break. Be back right after this.